already formed a quorum and it's the appointed time, and this is the subcommittee on the proposed resolutions under the Bankruptcy Ordinance and the Companies Ordinance. First, election of chairman. Can I have nominations from members, please? A valid nomination will have to be moved by one member and be seconded by at least 2 other members, and will have to be accepted by the member being nominated. All right, Mr. Christopher Chiang. I'd like to nominate you, Chairman. Ting-kwong. All right, seconded by Mr. Stephen Ho. I accept it. Any other nominations?
好，如果冇其他提名，多謝大家。
If there are no further nominations, thank you for electing me. Do we need to have a deputy chairman? If not, I think this bill is very simple. So let's do away with the deputy chairman. We don't need one. Table before us is a submission from the Caritas Family Crisis Support Center. Please take a look. First, let's invite the administration team to join us. With us today are Ms. Teresa Wong, Official Receiver, Mr. Maurice Liu, Principal Assistant Secretary from the FSTB, and Ms. Cindy Check, Government Counsel from the DFJ. Welcome to you. First, let's invite the administration team to walk us through the 4 resolutions under the Bankruptcy Ordinance and the Companies Ordinance. Which one of you to walk us through that? Yes? Under the present Bankruptcy Ordinance and the Companies Ordinance, we have statutory fees, charges and deposits, and such fees and charges, according to our calculation, are the way to calculate the level would be based on cost recovery, in order to ensure that the cost will not be passed on to the taxpayers. Recently, there was a review on all the statutory fees, charges and deposits. We expect that in 2013-14, the cost recovery rate would reach 110%. We believe that there is room for us to adjust certain fees and charges downwards. Altogether, we propose to revise 31 fees and charges downward, and out of them, 26 are statutory fees. 3 are deposits. 2 are percentages. So they are based on certain percentage. The previous review was done in 1997, and for the 29 fees and charges, we'll be reducing that and reverting them back to the 1997 level. As for the 2 realization fee by a fixed rate, they will also be adjusted. So Mr. Lu, can you walk us through those? All right, Mr. Lu. Yes, in fact, the OR already explained most of it. We have about 13 or 14 fees that are related to winding up cases. So they are statutory minimum fees. And for the 26 fees and charges, we'd like to bring it back to the last review level, that is 1997. At the same time, we also have 3 so-called statutory deposits. So they are just deposits. And we are also proposing that for the 3 deposits, they should also be reverted back to the 1997 pre-adjustment level. And there are 2 so-called realization fee, and as the OR just said, is charged on the basis of a certain percentage. And after reviewing it, the ORO is of the view that there is room for us to adjust such fees and turn it into a fixed fee. A total of 31 fees and charges are therefore going to be adjusted. And according to the ORO's study, with the 31 fees and charges adjusted, the cost recovery rate for the department would be going back to 100%. Thank you. Any questions? Yes, Sin Chung Kai. Chairman, I note that, it's a very simple question. All right, last year, for the cost recovery rate, all right, you now said that it's at 110% or 111%, so you have overcharged. So you're actually charging those who are deprived already. So after the reduction, you'll be recovering about 100%. So what about the overcharge amount? Are you going to reimburse them? Ms. Wang? No, we are not going to do that. There are some difficulties as to how we're going to distribute that. All right, you are actually recovering some 111%. So how much more have you overcharged? So how much have you overcharged them? By what margin? Give me a minute. All right, give me a minute. I'll give you that figure later. You have brought that with you? Yes, should be. Yes, can I supplement oral? Because as we all know, for government fees and charges in particular, if they are pegged to the cost, there'll be fixed, there'll be regular reviews of the fee and charges. And of course, in the day-to-day operation in particular, as far as the ORO is concerned, the revenue would be affected by a number of factors. For example, how many cases there are. In fact, from the ORO's perspective, it's very difficult for us or for them to estimate. All right, Mr. Lu, well, I think it's you'd better not refer to this. But then how many fees and charges set by the government have not been able to recover the full cost? I think in most cases they have not been able to recover the full cost. But then on this occasion, these are the worst off people. All right, they are going bankrupt and you're actually overcharging them. I think there are many institutions who have not been charged the full cost. So they are not the worst off ones. And then the financial secretary is actually exempting the business registration cost and so on. So every year when he dishes out goodies, why hasn't he taken care of these people? These are the worst of people. All right, for business registration fee, you're actually giving them waivers year after year. How about these people? You have never taken care of them. In fact, well, actually, for these bankrupts, most of them do not have any access. So even if we have this minimum charge of $12,150, we have not been able to get anything from them. All right, Mr. Chen Kai-chung already criticized you for not for not doing enough. All right, these are bankrupts. You're not going to take care of them. Next, Sid Ho. Thank you, Chairman. In fact, for bankruptcy-related fees and charges, in 1999 we had this financial crisis, and many have actually become negative asset owners after they have been encouraged by the administration to buy their own homes. So I don't know how they managed to get the $8,000 plus to apply for bankruptcy. So I'd like to ask the officials, would there be a mechanism in place to ensure that for those who are not able to afford it, all right, they said that some 50% have default cases. So what are the procedures? Does it mean that they will have to pay the $8,000 plus before they can submit their cases to the ORO and have their cases taken care of? Or is it that they will still be able to do it, but then there will be a charge against them, and they will have to repay it later in time? And then for the $170 as a charge, well, in the electrical brief, para 2C, the last part, you also have this fixed fee, and it's done or is charged on a full cost recovery basis. All right, they're already bankrupt. You're actually charging them $170, which is a very small sum. All right, even if you're trying to go for the nitty-gritty, but then you must ensure that they have they are able to have their cases processed by the ORO. So can you tell us the procedures? All right, the procedures are like this. Well, for a bankrupt, he will have to put out some $8,665 to the ORO as a deposit, and then for the $2,000 plus, that would be a deposit in a court before he can apply for bankruptcy. So that's true. And also for the minimum fee, at present is $12,150, but then we have not been able to recover everything because in majority of the cases, over 50% of them do not have any assets. That's why we have not been able to get the $12,150. For the $8,650, that would cover a lot of costs: Gazzetto, putting up advertisements in the newspapers, search in the company's register, and also search with the land register, and also traveling expenses and so on. So that would already take up a lion's share of what they have paid. All right, during the years of the financial tsunami, there were many negative asset owners, in particular those who have been tempted into buying home ownership schemes from public housing estates, and many of them have actually received a pay cut. That's why they have nowhere to turn to but to go for bankruptcy. All right, for land search and also the traveling expenses, that's why they will have to deposit $8,000 plus into the ORO before they can apply for this procedure. But can you simplify the whole thing so that for people who are really living on bare wages, so they will be like owing you a debt, and then they can repay it later, or else they can't even enter the process. All right, you're already bankrupt. Can you tell people that I'm going bankrupt, that's why I'll have to take out a loan from you? Who would be bothered to give this loan to this poor guy? So under the existing procedures, all right, if I am already so worst off that I don't have a cent with me and I have to go bankrupt, so is it possible that I can still apply for bankruptcy before I repay the debt later? All right, well, how come we have to set up this subcommittee even though the changes are very technical in nature? You just change the figure.
Official receiver. At present, we don't have this legislative means. So it means the person has to get the $8,000 plus. Otherwise, there's nothing he can do. He doesn't have a cent So, do you agree with the way I put it? OR? Is that the case? Now, at present, it's difficult because we have to recover the cost, because otherwise the taxpayers have to pay. Now, I want to understand this issue better. Is it possible for other departments that can handle this amount that involves legal costs, etc., and pay to the ORO? What I mean is, can the legal aid department, the SWD, do something? Or can the petitioner rely or be assisted by some funds? Are there other means for the petitioners? OR? At present, I don't know. Can the administration consider these points we made? We're talking about a very minor amendment only. Sorry, Ms. Ho, I have to interrupt you here. Now, let's say your department and other departments cannot provide a loan to these people. Have you come across any bankruptcy cases that could not be dealt with because of the lack of means? Now, if one person can't pay $8,000, he can't even make a petition. So I think it's hard for us to know whether there are any precedents. But OR, what's your reply? Ms. Ho got it right. We don't know how many there are. Going bankrupt may be the last resort for one person. Now, these people sometimes want to have a sort of restructure of their loans. So this is a point for the subcommittee to consider. Now, just now, the OR said that for the $12,000 odd, 50% could not be recovered. Can I understand that a person has to pay at least $8,000 to make a petition? So people who can't pay that, you don't know what happened to them. You don't have a record. Now, for the $12,000 odd, how many people could not pay that? And what's the level of their debt? Now, if someone has a loan of $200 million and he did not even save $12,000 to pay the minimum charges, then it's unacceptable. But for people who are affected by the financial tsunami, the really so-called small negative asset owners, do you have any figures concerning them? We want to know more about them. They were taxpayers before they go bankrupt. We have some data in the past 3 years. 37% of people did not have any asset. On average, there are 10,000 of such cases per year. We handle 7,000 plus of such cases. They amount to 37% of people without any asset. 51% lower than 10,000. The rest, 10,000 to 30,000 asset in terms of asset. Now, these people are really poor then. I look at bankruptcy in this way. As far as I understand, for someone to go bankrupt or for a company that has to be wound up, then it's up to the creditor to take action. For debtor to make a petition. We're talking about poor people who are making a bankruptcy petition. So the debtor has to pay, in other words. Yes. So what about the winding up of companies or an individual petitions for bankruptcy? Do you have any figures? For a debtor petition, about 10,000 cases per year. Creditors petition just 100 or so. Just several. Now, you can ask your friend to make the petition for you, and then you can save the $8,000 for yourself. Well, no, that's not the case. If it's the creditor who makes the petition, then you have to pay a higher fee, over $10,000. All right, then maybe you can pay someone to make the petition for you. Mr. Ting-kwong. Thank you, Chairman. Well, I don't quite understand what you mean by cost recovery. Different departments talk about recovery rate. Some departments break even. How many of the departments can break even? It seems to me the ORO is doing the best here. You break even. Is it because you charge a high fees? The debtor and creditor petitions OR quota is so small. 10,000 debtor petition, that will take you to just a small amount, and some of the debtors could pay, some not. Do you know the household income of these families? Say, for example, how many of these people earn 50% of the median household income? If we're talking about this group and you even charge them for $8,000, and for people who earn above the median household income, you're also charging the same level for these people. Do you think that you are actually taking resources from people who are already poor, as Mr. Sin put it? People who earn 50% of median household income, you have to charge them lower. For people who earn the median household income, you should actually charge them $8,000. Would you consider these practices? Now, you're here asking for a downward adjustment. Of course, we welcome that. But you have never thought about the needs for those who are worst off. These people have no choice but to make bankruptcy petition, and yet they have to pay over $8,000 to the government. Now, we are not talking about $8,000 because the petition is handled by lawyers. These people have to pay higher than $8,000, and they actually have to pay over $10,000. Some NGOs are helping these people, but they can't pay the $8,000 for these people. It means the debtors at the end of the day have to pay $8,000+. And these people do not have a chance to start afresh if they are asked to pay that amount. They have no choice, and yet you don't give them a helping hand. What sort of administration are we talking about? So my question for FSTB and ORO is, will you consider different levels of fees for people with different income levels? Mr. Liu, we discussed it at the relevant panel, the FA panel. Most of the petitioners have financial burdens, and we haven't got a system that differentiate the petitioners into those who have urgent needs to be helped and those not. So we don't have different level of fees for different groups of people, because we understand that for all these people, they have financial burdens. For the process of petition of bankruptcy, in other jurisdictions, statutory fees are also imposed. Say, for example, in Singapore and in the UK, the petitioner has to pay a deposit before the procedure can go any further. And even in Singapore, there is no division between different petitioners. I'll see if the OR would like to supplement. A member asked about the statistics. From 2008 to last year, petitioner with no income amounts to 38% of the total. So zero income, right. Those earning below 10,000, 40% approximately. And these two groups amount to 77% of the total number of cases. People who don't have any income means they don't even have $8,000. So how can they make a petition then? I don't think the OR knows about it. Now, some people may borrow 8,000 just to make the petition. These people may report they have no income. You mean they have no income, but yet they have some savings? Now, people from NGO are actually working with the bankrupts. Say, for example, they will restructure the loans, and if that doesn't work, these people will make bankruptcy petition. But then the NGOs saw that the bankrupt really have a hard time. Some people have to ask their relatives to lend them 8,000 just so their petition can go forward. That's why I asked if the administration would consider different levels of fees for different groups of people. I'm not saying we have to follow other jurisdictions. I think we should come up with our own ideas. Now, Chairman, I think you made a very good point. If the ORO is not going to take it up, will other government departments be able to help these people? But the administration doesn't give us an answer. In many cases, NGOs are helping these people. I think we should ask these NGOs and the lawyers who are helping the bankrupts to come and tell us their experience. I think the Home Affairs Bureau and other relevant departments should also tell us if there are any funds that can help these people to tide over the difficult time. I would like to put forward the suggestion. All right. We can allocate some time to discuss your suggestion. Next, Mr. Ting-kwong. I agree with Mr. Cheng's suggestion. At the FA panel, we spent only 40 minutes and 30 minutes on this item, and just 2 or 3 members talked about it. Maybe the FA panel had other more pressing issues to discuss at that time. On the district level, I can tell you, when people have no means, they don't know who they can turn to get the $8,000, $9,000. I already said that these people have no choice but the followings. So, for example, they can hide from the creditors, or they can try, say, break the law and make their petition in any event, or they have to ask people to lend them money. And at present, some so-called professional companies claim that they can help people to make bankruptcy petition. Now one has to pay $20,000, and $9,000 of which will go to the consultancy. Even for the bankrupt, the petitioner, he is working, and now he has to pay these companies. So now I'm telling you, these are the loopholes existing in the community. I'm sure Hong Kong people value their reputation, their credibility. People would not file a bankruptcy petition just because you lower the fees. There is a high suicide rate, especially amongst males and middle-aged males. They already suffer if they have to file for bankruptcy, and yet they even have to go to other people to ask for a loan of $8,000. It's even worse for these people. So I would like to listen to the experience of the NGOs and groups that have helped these people. Now, the downward adjustment of fees is welcome by us, but I think the administration should also consider setting different levels of fees for different groups of people. While I'm only here to listen to views, I can't make any decision. Now, official receiver for debtor's petition. Have the ORO followed up on these cases?
Well, they will have to fill in a form, and we will ask them a number of questions. That's the preliminary investigation form. We have to ask them why they have to petition for bankruptcy. Some said that they've been dismissed. Some said that they lost a fortune in gambling and so on. All right. Some said they've been sacked. They're out of a job. All right. If they have been out of work, why would they be so heavily indebted that they will have to file for bankruptcy? All right, they might have difficulty if they've lost a job. They could ask for, or they could apply for welfare. All right, my understanding is that if they're indebted, all right, if I have difficulty making ends meet, let's say, if I'm already very worse off, then I can at least approach the social worker, and then I'll be able to at least make a living. But then I'm actually filing for bankruptcy so that I'll be free from all my debt, and then 4 years later I'll be able to turn over a new leaf, and nobody will be able to go after me for what I owe them. All right, that's my understanding. All right, you said that being indebted because of gambling. All right, the pathological gambler, and in the end, I'll just file for bankruptcy, and I'll take out loans from the loan sharks, and after I have become a bankrupt, nothing can be done about it. But then I don't quite understand what you said. Well, for people who have been dismissed, all right, if I've been dismissed, then, well, even if I am ill, even if I'm not able to afford the medical expenses, then under Hong Kong's public health care system, I'll still be able to go into a public hospital. And if I can't afford it, I can go to the Samaritan Fund to apply for help. So there are many avenues available for me to seek help to resolve some normal difficulties, unless I've taken loans from the loan sharks or from banks and so on. And in the end, I have no alternative but to file for bankruptcy. According to some of my lawyer friends, they've seen a lot of these cases. And as far as this bill is concerned, recently, well, normally I do not have many contacts with these people, but then after I have looked at this bill, I try to find out what's happening. All right, for companies complaining about being deprived, I can understand it. All right, they can be filed for that. They can go into liquidation, because even for the creditors, all right, nothing can be done about it. They will not be able to get back anything. All right, for private individuals, I don't quite understand it, and that's why I try to ask around these days, asking my friends and lawyers about what happened to these people. Ms. Sito, yes, indeed, if we can have a public hearing so that those who have first-hand experience might be able to share with us how they feel. All right, for those in business, all right, even if they are not able to repay their debt, then of course there is a chance that people might file for their bankruptcy. So they have to deal with a lot of liquidation problem and so on. But then for people who aren't even able to make ends meet, so how come they could become so deprived? All right, even if they apply for welfare, they will have to queue up, and Mr. Peter Cheung might have more experience to share with us. Even if you apply for emergency aid or relief, then unless it's a real emergency situation, that can be fixed in a couple of days. But then for CSSA, all right, there is also a cap on rent assistance. But then for private sector housing or private housing is always somewhat more expensive than the cap. Therefore, I think we have to talk to the social workers, welfare agencies, or social service agencies, and those who have first-hand experience. They will have to tell us what they've been through, how they can get the $8,000 before they can get their cases processed. So even for me, I don't think I have a lot of experience in this. This Ms. Ho, yes, I've been thinking about this lately. But then, well, for 8,000 plus, well, even if it's waived altogether, then after you file for bankruptcy, then even after you've come out as a bankrupt, still you won't be able to resolve the problems that you had in the first place, and after 4 years. All right, you're a new man, and if you repeat the same mistakes, then you have to file for another bankruptcy. So what happens is a never-ending story. So as an individual, as a human, so you're actually going down slope all the time. Chances are that when you get older, you would be worse off. Even if you manage to get one fee waiver, according to what you said, they would only get some short-term relief, and then after a while, they'll get back to their road self again. So, what's the relationship between the ORO and the SWD? These people should have been taken care of by the SWD, right? After all, you're talking about welfare problems. But then the ORO is supposed to deal with economic issues and cases, so it's not supposed to be involved in welfare. Mr. Peter Cheung. Well, Chairman, let me explain a bit what the thinking is, and Mr. Lu might also comment on it. Well, my understanding is, well, setting aside those who can afford the $8,000, I don't know if people might think that there are some who are abusing the system. Well, for those with good intention, all right, bankruptcy is the last resort. And if they are willing to reflect on themselves, or if they have been assisted by social workers, yes, Chairman, I agree with what you said. All right, every year you're talking about 10,000 plus cases. So you're actually talking about 10,000 families who are suffering. How many of them would approach the social worker so that they'll be able to stand back on the ground themselves? But then, to a certain extent, some of these bankrupts might seek the help of social workers, and if the ORO can make referrals and can work with the SWD, you might be able to help many who, according to the chairman, might repeat their mistakes, and with their help, they might be able to really turn over a new leaf and re-establish their confidence and self-esteem, so that in the next 4 or 5 years, they will be able to stand up on their own. So some of them might even be able to repay some of the old debts. That's precisely because they will not be using bankruptcy to get away with their past debts. So if the ORO can refer these individual bankruptcy cases to the SWD, then there will be a very good interfacing. So I think, Chairman, you came up with this very remarkable idea. I think it's brilliant. So, Mr. Lu, can you comment on this? Yes, that can be considered. The ORO in the day-to-day operation in dealing with these cases can have better liaison with the SWD. Yes, that can be considered. Yes, Mr. Chang, I think what they just said is really a very sincere decision, because the ORO is supposed to deal with some technical processing and governance operation. It's not about individual departments carrying their own business. It's about the entire community, and all are interrelated. And if there can be such connection between different departments so that they can work together to help solve these problems, then there will be greater harmony in our society and fewer social conflicts. And my personal feeling is, to a certain extent, when it comes to the relevant charges by the ORO, it's a procedural charge, and therefore it should not be dealt with as if it's welfare. There should be other departments to help those in genuine need. To be honest, if you ask for my personal opinion, for people who have become indebted because of gambling, well, even if they might have their past glory, all right, they might be rich one day and then they'll be very deprived the next day. Well, I would not pity them. Well, I've got a friend and I try to help him, but then in the end, I have to give up. And then as the ORO, it will be difficult for them to distinguish between different types of people. And therefore, it should be for the social worker to conduct in-depth investigation. All right, people have suffered as a result of their it's no fault of their own. Then if they have got into this quagmire, then of course the SWD should reach out to help them. It's not about helping them and lift them out of bankruptcy. It's about, well, bankruptcy might just be one component of the whole thing. So we should be helping him to resolve his other problems as well. So we should be more thorough instead of just focusing on this very small element of bankruptcy. Yes, Mr. Dr. Lo Kwok. Chairman, if you require the ORO to assess whether or not this person should be treated sympathetically, and therefore there should be a waiver for him. I think it would be too difficult. We are making life impossible for the overall. We should just follow the established principles. That is, we would just recover the full cost. But then, if some of the prospective bankrupts, if they need help, then they should be assisted by the welfare system. And if that system is not working well, then I think there should be another committee to look into it in order to improve the system. If that's not the way to go about it, then for this subcommittee to discuss this issue, it might mean that there'll be no end in sight as to how far we should go. Well, with regard to creditor and debtor petition or cases, well, is there any difference? Because in the past, if it's a creditor petition, yes, it's okay to charge him higher, but then because there is some cross-subsidy element here, and if that's the practice in the past, then my question is, you said that it'll be pegged to the cost, but then I don't think you're calculating, it's not an exact science. So for the debtor petition cases, there should be a more substantial adjustment, and then for the creditor petition, there doesn't need to be such a hefty downward adjustment. All right, the number of cases might be small, but then there is a symbolic meaning. OR or PAS? Well, let me explain. At present, concerning creditor petition and also debtor petition, there is a distinction, because for the latter, well, they will have to pay more, and we are actually proposing downward adjustment for both. As to the extent of adjustment, we try to take a more simplistic approach. That is, we'll revert the fee level to the pre-1997 level. So we will just be setting it at the pre-1997 level, because, well, if we reduce one more substantially, then that might not be fair to some, and therefore we try to revert both to the pre-97 level. All right, you're reverting it to the 97 level. Well, Chairman, my understanding is that in terms of the figures, all right, well, there are fewer debtor petition cases than creditor petition cases, but then if we were to, well, why do we have to revert it to 97 level? Well, for the creditor petition cases, we can keep it at the present level, and then for the debtor petition, we can adjust it downward more substantially. Can that be done? Oral or who? All right, you well, you status quo for one, and then more substantial cut for the other. I think we will have to think more carefully about whether this is fair. So, well, some might say that I'm not going bankrupt because you're not lowering my fee. I think that the administration has already answered your question. All right, on the principle of fairness, they're not going to do what you ask them to. Yes, Mr. Ng Sing. Yes, I have heard the views from different perspectives. Well, as a banker, I've often come into contact with such cases.
Some people can't pay the debt after taking out a loan. Well, there should be a solution. And I don't think we should drive people to a cul-de-sac. One of the way out is to file bankruptcy petition. Having done that, the debtor can start afresh after several years. Now, we're talking about something that's relatively simple, that is the charges, the fees. Now we're using public money to fund the whole process. And should we fund the way forward for the debtor with public money? Now, I understand that in Singapore, in the UK, there are relevant charges too. But for people who can't pay the fees and who are filing bankruptcy petition, what should we do? You can't say because the person can't pay the fees, then the petition can't go any further. That can't be the case. I think this problem can be dealt with via technical means. The person has to pay fees to handle the application and to pay the deposit. I think we can give some discretion to these people. If not, these people won't even find a way out of bankruptcy and to turn a new leaf. Not doing anything for them would not be reasonable. So will the administration exercise some tact in granting discretion? And meanwhile, you can also put money to good use and not waste public money, because at the end of the day, we're talking about public money. So can we straighten out the matter so that people will not think the government is spending away the public money, and yet meanwhile we can also help people who can't pay the deposit. Now this is the view of Mr. Ng, and I think it's reasonable. Now for people who can't pay the legal fees, legal cost, that is the LA department for them. For people who can't pay the fees to file bankruptcy petition, shouldn't there be some assistance to them as well? Now this may not be directly related to our topic today, but please think about it. Any further questions? If not, I have something to ask members. Mr. Peter Chang asked to have an open hearing, a public meeting with deputations. We will invite the 18 district councils and relevant organizations, in particular the welfare organizations, financial centers, and the banks. We will send invitation to them to invite them to add their views to us. And this arrangement will also be uploaded to the LESCO website. And I propose 3rd of October, a Thursday, 2:30 p.m. On that day, we should have the next meeting, and at that time, we will meet with deputations, all right? Is it agreeable, members? Mr. Chang. Well, OLO will be represented, I'm sure. Can we also ask representatives from HAB and LWB so that we'll know whether there will be some other means of assistance to the people who can't pay the fees? I have to ask the Secretariat. Well, this is just a suggestion. This is a subcommittee, not a panel. If we take up your suggestion, then the matter has to go back to the panel, because this subcommittee is not related to social welfare. The suggestion can be passed on to the administration, but never ever has any subcommittee held meetings that deal with issues that is not related to the items tabled. I have to ask the Secretariat if we have such precedents. So I'm afraid I can't really invite representatives from other bureaus except the ORO and the related departments that are related to the bill. If there's nothing further, that's all for today. All right?
多謝。